Environmental Protection Agency? So the Environmental Protection Agency was established by President Richard Nixon in 1970. It is an independent executive agency of the U.S. federal government, and its task is environmental protection matters. It began operation on December 2, 1970, and the EPA administrator is appointed by the President and approved by the Senate. The EPA headquarters are in Washington, D.C. There are regional offices for each of the agency's 10 regions and 27 laboratories. The agency conducts environmental assessment, research, and education. And as of 2021, it had 14,297 employees. Over half of its employees are engineers, scientists, and other environmental protection specialists. Other employees include legal, public affairs, financial, and information technologists. The Environmental Protection Agency can only act pursuant to statutes. Those are laws passed by Congress, but it has the power to issue regulations. So a regulation interprets a statute, and the EPA applies its regulations to various environmental situations and enforces the requirements. The agency must include a rationale of why a regulation is needed, and regulations can be challenged in federal courts. And I'm going to give you an example at the end of the lecture of a regulation that was very controversial and challenged in the courts. So EPA enforcement powers include fines, sanctions, and other measures. The EPA has an Office of Enforcement and Compliance Assurance, which works with regional offices and in partnership with state and tribal governments and other federal agencies to enforce the nation's environmental laws. It enforces the Superfund Act, the Clean Air Act, the Clean Water Act, the National Environmental Policy Act, the Oil Pollution Act, the Resource Conservation and Recovery Act, the Safe Drinking Water Act, and the Toxic Substances Control Act. Now, the Clean Air Act was one of the nation's first environmental laws, and it was the first major environmental law in the United States to include a provision for citizen suits, lawsuits by private citizens to enforce the statute. It is administered by the Environmental Protection Agency, and it was amended in 1965 by the Motor Vehicle Air Pollution Control Act to authorize the government to set emission standards for certain automobiles. An emissions or an air pollution testing system for motor vehicles was developed in the 1970s. It was originally a bit controversial. The automobile industry said it couldn't meet the new standards, and some U.S. senators were worried that it would have a negative impact on the economy. But the stricter standards led to the creation of the catalytic converter, which was a revolutionary development and lowered emissions significantly. The converters didn't work with leaded gas, and that contributed to the removal of lead from gasoline, and this also had positive health effects. The EPA conducts fuel economy tests, but only on very few vehicles each year. It conducts about 18 employees conduct about 200 to 250 vehicle tests per year, which is only about 15% of new models. 2/3 of those models are randomly selected, and the other third are selected because they have new technologies or they're new manufacturers or something that attracts the EPA's attention. You can see the picture on the lower right of some of these employees conducting emissions tests. The Clean Water Act. This was enacted by Congress in 1972. It established mandatory water pollution control standards to be implemented by the EPA in partnership with the states. In 1972, Congress required the EPA to measure every pesticide's risks against its potential benefits. So the EPA uses a permit system for regulating point sources of pollution. Point sources are industrial facilities like manufacturing, mining, shipping, oil and gas extraction, and other industries. Municipal governments, especially sewage treatment plants and other government facilities like military bases. Some agricultural facilities like animal feedlots. And these point sources may not discharge pollutants into surface waters, lakes or rivers, without a permit. And the system was managed by the EPA in partnership with state environmental agencies. The EPA develops mandatory federal standards for all public water systems that serve 90% of the U.S. population. And they enforce these standards with the cooperation of state agencies. The EPA is required to set standards for drinking water quality and to oversee all states, localities, and water suppliers. And the Safe Drinking Water Act that gives us these duties and authorities applies to every public water system in the United States. But the Act does not cover private wells. 13% of U.S. households in 2020 still used private wells, so they're not covered by the Safe Drinking Water Act. It also does not apply to bottled water. Bottled water is regulated by the federal government, but by the Food and Drug Administration, not by the EPA. So, the EPA develops national primary drinking water regulations. It establishes these regulations for contaminants that may cause adverse health effects. The regulations include both mandatory requirements and non-enforceable health goals for each included contaminant. As of 2019, the EPA has issued 88 standards for microorganisms, chemicals, and radionuclides. For some contaminants, the EPA establishes a treatment technique instead of a maximum contaminant level, and the treatment techniques are enforceable procedures that drinking water systems must follow in treating their water for a contaminant. So it identifies 88 contaminants, right? These might be microorganisms, might be chemicals, and it either mandates a treatment technique. So if you have this contaminant in the surface water or in the groundwater, you have to treat it, or in the drinking water, that is. Or instead of a treatment technique, it might have a maximum contaminant level. So your drinking water can't have more than a certain amount of this contaminant, or it's considered unsafe. Public water systems are regularly required to monitor their water for contaminants. Water samples must be analyzed using EPA-approved testing methods by laboratories that are certified by the EPA or a state agency. And a public water system must notify its customers when it violates drinking water regulations or is providing drinking water that may pose a health risk. The Toxic Substances Control Act was passed in 1976, and this relates to the manufacture, labeling, and usage of commercial products. The three main objectives were to assess and regulate new commercial chemicals before they enter the market, to regulate chemicals already existing that pose an unreasonable risk to health or the environment, such as polychlorinated biphenyls, lead, mercury, and radon. The manufacture or importation of chemicals that are not on the TSCA inventory or subject to one of many exemptions is prohibited, and manufacturers must submit pre-manufacturing notification to the EPA prior to manufacturing or importing new chemicals for commerce. The EPA reviews new chemical notifications, and if it finds an unreasonable risk to human health or the environment, it may regulate the substance from limiting uses or production volume or just outright banning it. So this is meant to screen, right, new chemicals before they're on the market in order to assess whether or not they present a risk to the public. In 1976, the Resource Conservation and Recovery Act tasked the EPA with setting national goals for waste disposal, conserving energy and natural resources, reducing waste, and ensuring environmentally sound management of waste. The EPA developed regulations for solid and hazardous waste that were to be implemented in collaboration with states. And this system is largely managed by state agencies under EPA authorization. Standards were issued for waste treatment, storage, and disposal facilities, and the ocean dumping of waste was prohibited. Now I want to talk about a specific incident, a very famous incident that led to a new program that the EPA was responsible for, and that in many people's minds, this incident is associated with the Environmental Protection Agency and for why it was necessary. So Love Canal, it was a region near Niagara Falls, New York, and it was the location of a 70-acre landfill that became the site of an enormous environmental disaster in the 1970s. So in the 1920s, the canal, originally it was a canal, or it was supposed to be a canal. In the 1890s, I think, someone wanted to build a canal, and they dug the ditch for the canal, and they named it Love Canal, but it never became a canal, and they just left a ditch there by the early 1900s. So in the 1920s, the canal became a dump site for municipal refuse for the city of Niagara Falls, in other words, garbage. During the 1940s, the canal was purchased by Hooker Chemical Company, which used the site to dump chemical byproducts from the manufacturing of dyes, perfumes, and solvents for rubber and synthetic resins. And allegedly, decades of dumping these toxic chemicals harmed the health of hundreds of residents in the area. During early 1978, a reporter named Michael Brown investigated potential health effects by performing an informal door-to-door survey, and he wrote news items on toxic waste in the area, and he found birth defects and many anomalies such as enlarged feet, heads, hands, and legs. The New York State Health Department investigated and found an abnormal incidence or number of miscarriages. And by the end of 1978, Love Canal had become a national media story, with articles referring to the neighborhood as a public health time bomb and one of the most appalling environmental tragedies in American history. I should probably mention where the canal had been used as a dump for many, many years. First by the city and then by this chemical company. And then it had been covered over. So it wasn't just an open garbage dump by the 1970s. But they had filled it over with dirt, and they had built a school on top of it and a playground. And so you can imagine how upset these people were years later when they realized that the playground their children were playing on was literally on the top of a toxic waste dump. So on August 7, 1978, President Jimmy Carter announced a federal health emergency and called for the allocation of federal funds, and he ordered the Federal Disaster Assistance Agency to assist the city of Niagara Falls to remedy the Love Canal site. This was the first time in American history that emergency funds were used for an environmental mess rather than a natural disaster. The emergency disaster declaration led to the evacuation of about 900 families and the bulldozing of the elementary school and 2 streets. In 1978, the EPA announced the results of blood tests which showed that the Love Canal residents had high white blood cell counts, which were a precursor to leukemia. They had chromosome damage. 33% of the residents had chromosomal damage, whereas in a typical population, that would affect about 1% of the people. So, in 1980, this law was passed, the Comprehensive Environmental Response, Compensation, and Liability Act, better known just as the Superfund. So this created a tax on the chemical and petroleum industries and provided the federal government broad authority to respond directly to releases or threatened releases of hazardous substances that might endanger public health or the environment. The act also created a national priorities list, which was a list of the sites that have priority in cleanup. And Love Canal was the first Superfund site on the list. And it was cleaned, supposedly, and deleted off the list in 2004. There are 40,000 federal Superfund sites across the country, and approximately 1,600 of those sites have been listed on the national priorities list. The EPA seeks to identify parties responsible for the pollution and compel them to clean up the sites, or it may undertake the cleanup on its own, using the Superfund or the trust fund, and seek to recover those costs from responsible parties through settlements or other legal means. About 70% of cleanup activities have been paid for by the responsible parties, but 30% of the time the responsible party either cannot be found or is unable to pay, and in this case, taxpayers pay for the cleanup. So the Superfund, in plain terms, taxes chemical and petroleum industries. This creates the fund, and the fund can be used to help clean up the sites. Right? And Love Canal was the first one on the list. And you can see by these dots where some of the others are. Another thing that the EPA does that you might have seen is the Energy Star program. This is a voluntary program to promote energy efficiency. It was initially a voluntary labeling program designed to identify and promote energy efficient products. So for example, Energy Star qualified fluorescent lighting uses 75% less energy and lasts up to 10 times longer than normal incandescent lights. The program began with labels for computer and printer products. It was expanded in 1995 and included labels for residential heating and cooling systems in new homes. It can now be used on more than 75 different certified product categories, homes, commercial buildings, and industrial plants. So basically, if you have a product you think is energy efficient and it qualifies according to the EPA, you can slap the Energy Star logo on it and use that, to help market it as being energy efficient. Now, let's get into some of the more controversial stuff. There are reasons why some people get angry at the EPA or disagree with the EPA. This is one example of something the EPA did or allegedly did that upset many people. The Gold King Mine wastewater spill in 2015. So the EPA, along with a company under EPA contract to mitigate pollutants from the closed mine, the Gold King Mine was a mine that had been closed for many, many years, and the EPA was going to clean it up. Right? But they actually caused the release of toxic wastewater into a river, the Animas River. They were attempting to drain ponded water near the entrance of the mine, and they accidentally destroyed a plug holding water trapped inside the mine. This caused an overflow of the pond, spilling 3 million gallons of wastewater into the river. And this river flowed into Colorado and New Mexico. It was in Colorado where the mine was, but it flowed into New Mexico as well. The EPA didn't warn Colorado or New Mexico about the operation until the day after the wastewater was spilled, despite the fact that the EPA employee in charge of the gold mine knew of a risk for blowouts. And the EPA admitted responsibility for the incident but refused to pay for any damages, file any claims filed for damages after the accident on grounds of sovereign immunity. So they were supposed to clean up a pond in front of an abandoned mine, and instead of cleaning it up, they released 3 million gallons of waste, making the problem infinitely worse than it would have been if they had done nothing at all.
Are you still there?
Yeah. Well, I expect it got cleaned up, but they didn't do it. The states of Colorado and New Mexico, I think, had to do it. So, should the EPA regulate greenhouse gases? Is an interesting question. And it has been a hotly debated question for almost 20 years now, and it ended up in the Supreme Court. This is the case I was referring to earlier when I said you can challenge EPA regulations in federal courts. If you think that the regulation is unconstitutional or illegal in some way, you can challenge it in court. So in June 2014, the United States Environmental Protection Agency proposed the Clean Power Plan. The rules in the Clean Power Plan, this is a regulation, right, aimed to tackle climate change by requiring reductions of carbon dioxide emissions from electricity generation by 32% of recorded 2005 levels by 2030, with the implementation to be done by the states. And the EPA said it was granted the authority to make this rule, this regulation, the Clean Power Plan. It was granted this authority under the Clean Air Act. So the states would have been required to submit implementation plans by 2018, with enforcement to start by 2022, and states could require existing power plants to implement efficiency improvements, emissions controls, or incorporate renewable energy generation. But the CPP, the Clean Power Plan, did not go into effect. It was challenged in courts and it was stayed. Anyway, what's interesting though is even though the Clean Power Plan didn't go into effect, its goals were met in 2019 by energy efficiency, construction of wind and solar power, and a general shift from coal to gas in that time period. So what I want to do next, I'm going to show you 2 quick videos. One by the EPA itself. It's about 5-7 years old, and it's them explaining the Clean Power Plan. It's about 3 minutes long. And then I'm going to show you a video about 3 or 4 minutes long from a group called the Federalist Society. It's a conservative think tank, and they tend to oppose big government. They tend to like smaller government, limited government. So it will explain what the objections were to the legality or the constitutionality of the Clean Power Plan.
Hi, I'm Joe Goffman, and I want to tell you about EPA's proposed Clean Power Plan to cut carbon pollution from power plants by 30% by the year 2030. By looking across our whole power sector, we can take this important step to boost our economy, protect our health and environment, and fight climate change. Coal, natural gas, hydropower, nuclear, wind, and solar. All of these supply the electricity that we use every day in our homes and businesses. But when fossil fuels like coal are burned to produce electricity, they release carbon dioxide, trapping heat in the atmosphere and leading to climate change. Global climate change could threaten our very way of life. Floods can destroy our homes and communities, drought can disrupt our food production and water supplies, and severe weather can cause costly damage to our nation's economy and infrastructure. The best and cheapest way to cut carbon pollution is to generate more power from the cleanest sources and then use that energy more efficiently. Each part of our system offers huge opportunities to reduce the pollution that leads to climate change. We can make improvements at power plants themselves. We can expand renewable energy, generate more of our electricity from cleaner sources, and increase energy efficiency. EPA is not doing this alone. States, cities, and businesses have already shown that with these steps, they can waste less energy, cut pollution, and still provide the power we need to keep our economy growing. And most importantly, we can protect our health and our climate now and for future generations. Before we wrote the proposal, we heard from thousands of people on the best way to move forward. We learned that by providing enough time and flexibility, in 15 years, we can cut carbon pollution from the power sector by at least 30%, with significant cuts starting in the early years of the plan. We can also cut the pollution that leads to smog and soot by 25%. Yet even with these big reductions, coal and natural gas will continue to supply most of our electricity in the future, with each projected to provide more than 30% of our power in 2030. In the coming months, we'll be listening to feedback on the proposal, and we want you to be part of the conversation. Learn more at our website.
President Obama issued an executive order containing a climate action plan that directed EPA to reduce greenhouse gas emissions from power plants that produce electricity. The Clean Power Plan was the culmination of that executive action. It was a regulation promulgated under EPA's authority to reduce the amount of fossil fuels that would be combusted for power in favor of renewable sources. Traditionally, most electricity in the United States was made through combusting coal or natural gas at power plants. The Clean Power Plan required a significant reduction in the amount of energy that could be generated in that way. It's not really a pollution control program, it is an energy policy program. Throughout the country, citizens were unhappy with the prospect of losing jobs and higher energy prices. States who were affected were also unhappy, and of course, industries that were directly impacted. The challengers took the unusual step of going to the Supreme Court and asking for a Supreme Court stay. For the first time ever, in a case like this, the Supreme Court granted that stay. On the question of whether the Clean Power Plan is lawful, the best arguments rely on 5 words in the text of Section 111 of the Clean Air Act. Best system of emission reduction, in quotes. And EPA, in its litigation, did an admirable job of looking at that little phrase and saying, well, the Clean Power Plan gives states time to comply. It gives states flexibility in how they want to reduce carbon-based power generation. One of the biggest questions in energy policy over the last several decades was the extent to which the United States wanted to move to a zero carbon or lower carbon power economy through renewable sources and nuclear energy. There have been bills introduced every Congress for at least the last 20 years that would require this shift. None have passed. In a case a few years ago, the Supreme Court said that when an administrative agency claims to find a broad power in a long-existing statute, we look skeptically on it. For over 40 years, the Clean Air Act has been a pollution control program, not an energy policy program. Regulations can be undone by successor administrations. Executive orders can be undone by successor presidents. As much as this issue was a priority for President Obama, reversing it may well end up a priority of President Trump.
There we go. So, these two charts just show what critics complained about in terms of the policy effects they were afraid of from the Clean Power Plan, that it would have a negative economic impact. It would cause less gross domestic product, reduce household income, lead to manufacturing job losses, things that depended upon coal, I guess, principally. So there was fear that it would cause up to 2.7 million job losses, that it would reduce iron and steel production, cement production, refining production, and all of these things. These are some of the things that some people who were opposed to this plan were concerned about. So in August of 2015, opponents of the Clean Power Plan, which included 28 states and hundreds of companies, challenged the EPA's authority in its rulemaking for the Clean Power Plan. And they filed suit in the United States Court of Appeals for the District of Columbia Circuit, in other words, the DC Circuit, after the rules were published in the Federal Register. Their suit argued that the EPA's rule reached beyond their normal authority by giving states authority to regulate power plants across the board rather than at an individual plant level. On February 28, 2022, oral arguments were heard at the Supreme Court level, and the court considered if aspects of the case fell within its major question doctrine, which the Supreme Court has used to require the judiciary to defer to Congress rather than executive agencies on matters with what it perceives to be significant impacts and outcomes, if it believes Congress did not explicitly grant that power to the agency. In other words, the Supreme Court was concerned that the Environmental Protection Agency was using power that it had not been explicitly granted by Congress. Right? That Congress had not specifically given it the power to decide how much carbon emissions states could and couldn't have. The case was called West Virginia versus EPA. And on June 30, 2022, so just a few months ago, the court issued a 6-3 decision in favor of the states and the companies that were trying to strike down the Clean Power Plan. So the Supreme Court ruled against the EPA. The court ruled that the EPA does not have congressional authority to limit emissions at existing power plants through power generation shifting to cleaner sources. In other words, that the Clean Air Act did not specifically give the EPA the authority to order states to move from coal production to wind production, or coal production to solar production. Finding that the proposed action of the Clean Power Plan fell under its major question doctrine, the court decided that it required more specific congressional approval to be implemented. Chief Justice John Roberts wrote the opinion. He wrote that in certain extraordinary cases, both separation of powers principles and a practical understanding of legislative intent make us reluctant to read into ambiguous statutory text the delegation claimed to be lurking there. To convince us otherwise, something more than a merely plausible textual basis for the agency action is necessary. The agency instead must point to clear congressional authorization for the power it claims. So the court decided that the EPA did not have clear congressional authorization to limit carbon emissions in this case.